The, my client has some history, but it's not like a recent history at all. This was a long time ago.
You're honestly,
Previous
like,
history
whether
with
it's
that.
recent or not, the fact that he has violent convictions for a battery and an aggravated battery against the same victim, they still create this case being a felony, and they're relevant today, regardless of when they happened.
Hey there, welcome to the Courtroom Files. So this hearing is out of Fulton County, Georgia, and it involves the bond being set for the defendant, and we hear about some allegedly horrible things that he's done, and we get some very good verbal sparring between the attorneys, but towards the end, we also learned that it's not just him who's necessarily not the greatest person in the world. So take a look at this. Let us know what you think in the comments about the defendant, about the whole situation, and identify for me in the comments who you think is really the worse off in this situation. I think it's going to be fairly obvious, and they're going to be youthful people. But you let me know what you think. Please do put a thumbs up on the video if you enjoy it. Consider subscribing to the channel if you haven't already. Let's go ahead and roll the game film.
This is 25 CR 002715G, Jonathan Chern, charged at 1 count of battery family violence and 3 counts of cruelty to children in the 3rd degree. Actually, 4 counts of cruelty to children in the 3rd degree and 1 count of willful obstruction. So is that 1, 2, 3, 4? There's 6 charges. ASG,
Yes, Your
Alan?
Honor.
Okay, 6. Okay. All right, and let's see, pretrial. What do you have on Chern?
I have that history, Your Honor. This was a case that was originally in the felony in the DA's office, but for some reason was reduced and sent to us, transferred to us. This is an incident from November. The defendant was arrested April the 3rd. His criminal history includes a prior battery family violence and a prior aggravated battery family violence with cruelty in the 3rd degree associated against the same victim and children out of DeKalb County, which is why this was initially in felony superior court. So based on the statute, it should be a felony, but for today's purposes, that information is applicable for our bond consideration. The defendant has 2 prior convictions for violence against the same victim. Her name is Erica Johnson, E-R-I-K-A. A police report was made on November the 17th, 2024. On scene with the victim, Mrs. Johnson. She was seen to have bruising or swelling on her face and then bruising and lacerations on the inside of her mouth. She reported that the father of her 4 children who were present there at the time had repeatedly struck her in the face, causing this laceration inside her mouth and bruising on her face and swelling on her face. He also slapped her more than 5 times, she reported, on November the 9th, and had punched their son in the chest during that incident, their son Julian specifically. The report details follow-up with domestic violence investigator J. Brown Tony with APD, multiple interviews and conversations with the victim where she elaborated that the lacerations that were caused by this defendant on the inside of her face, because he struck her multiple times in November, caused it to hurt and have such a hard time she's unable to eat on that side for a period of time. Her mother, the grandmother of these children, was also spoken to. Warrants were obtained on November the 20th, so 4 days after the incident, 2024. And then the defendant was eventually picked up April the 3rd, 2025. Basically, since his arrest, he's been in constant contact with the victim, calling her from the jail, instructing her to write an affidavit, say you're not in fear, you no longer wish to pursue this, that you're okay with me having a bond, and you can even tell them I want an ankle monitor. He then gets on the phone with 2 of their children. They use different names for some reason, Mark and Eve, and tells them also to let the court know and write a letter saying that they're not afraid and that they want their daddy to come home. It is of note he had also a cruelty in the 1st degree case. from April 11th of 2024 for striking the same child, Julian, in his body. He spoke to that child during the same jail calls on the 28th of April. This is one of many, many calls, and tells him about that case and that he also needs to write a letter. Your Honor, so the children are all named in each accusation. There are 4 of them specifically, date of birth starting 2/10, 2/11, 2/16, and 2021. We're asking for a $15,000 surety, Your Honor. No contact with Mrs. Erica Johnson or any of the children with the last name Churn. I don't believe they're married. No drugs, alcohol, or weapons. We would request an ankle monitor as well as DVIP to begin enrolling and start participating.
All right. So that's 6,000 on each, 36,000.
I said 15, Your Honor.
Okay, give me the breakdown.
Let's see.
15,000 total, but 6 on the battery, I heard. No?
No.
Oh, okay. Didn't hear that. So give me your recommendation again.
We would ask for 8 on the battery. And then 1,000 on the obstruction and the other to be on the cruelties. There's a substantial issue here with repeated assaults against the same victim, coercion and control, attempting to suborn perjury and statements by her in order to make it so he has no consequence for his behavior. There are multiple prior convictions against this woman for violating and assaulting her in front of her children. He has had multiple arrests for assault on the children specifically. The defendant is not only a danger to the victim, but a danger to these children and frankly, anyone else in the community at this point. And that's why we're asking for a surety and an ankle monitor. Thank you. If you'd sound for Mrs. Johnson in case she was instructed to be here today.
All right. Miss Erica Johnson? Nope. All right, go ahead, Miss McLeod.
Yes, Your Honor. My client has been in jail for some time. He is not in a position to pay for bond. He specifically asked if the court would consider giving him a signature bond. He is the father of these 4 children, Your Honor. He has legal custody of them. I don't believe the state mentioned, but he and the alleged victim have been in a relationship for over 15 years. So that is some considerable time, and they do share these 4 children. He denies the allegations as stated in the warrant, Your Honor, and he said they were just having a disagreement over the children. He denies what the state is saying, that he struck her multiple times in the face, Your Honor. Even if the court is disinclined to give him a signature bond, I would certainly ask for a much reduced bond. He definitely is not in a position to pay for a $15,000 bond. So he's just going to be sitting in jail waiting if this bond is not made more reasonable or a signature bond. Also, this alleged incident happened last year, Your Honor, about, by my calculations, about 6 months ago. So I would like the court to take all of this into consideration in setting a bond for my client. Nothing further, Your Honor.
If I could just clarify, he had warrants within 3 days of this assault in November, and he just wasn't picked up until April. And he has been in custody in no bond status. So not only does he have prior convictions against this young woman, I'm not sure what him having custody of the children means. If that's out of Fulton County or DeKalb County, I can look into that. Please share. But I don't have any information that the biological mother of these children doesn't have custody of her children. He's been sitting in jail with no bond until today because the case was transferred to us. And again, I'm unclear why it was transferred to us because it seems very clear that we have visible injuries, an assault on this victim that was witnessed by multiple people, recorded statements to officers about being assaulted and how she couldn't chew as a result of it, an assault on a child at the same time, coercion and calls from the jail, as well as a serious criminal history. So I'm not sure why it was here, but he has been in no bond status rightfully until the DA decided to transfer that case to us.
Just because he was in no bond status doesn't mean he can't get an appropriate bond now, because it
I
is
don't think it
now
is.
a misdemeanor.
I'm not
Because,
arguing that he shouldn't get a bond today.
right, the
It's just
DA made,
disingenuous to say this happened a long time ago when in
well,
fact
it
he was
did.
out with active warrants and that he hasn't had a bond for some reason other than the fact that the case is so egregious a judge wouldn't give him one because he asked for one. He petitioned the court for a bond in this case multiple times and was told no. So
I
that's the reason
understand.
why he's in no bond status. It's just
I,
important to make all the facts on the record.
I understand. What I'm saying is, it is undisputed that he has been sitting in jail without bond for some time. So therefore, he has been unable to work. Since he's not working, it puts him in a position where he's unable to pay for a bond. That was the point I was trying to make. Had it been a situation where he had just come in, one could say he probably would be able to. But I'm just telling you that based on his financial circumstances, he would be unable to make bond because he's been locked up for some time. And also, it did happen in November. So, and these are people who have significant history together as a couple, well over 15 years. My client is 38. They've obviously been together since they were both quite young. I don't know anything about any calls or any of that, but I'm just asking for either a signature bond or a much reduced bond for my client so he can get out of jail. Nothing further, Your Honor.
All right. I'm not for sure what it'll take for Miss Johnson to feel safe. Usually when they come back and they've violated the previous orders, we do a cash bond so that he can understand he needs to leave this woman alone.
We would not object to a cash bond, Your Honor.
Your Honor, I do not think my client has some history, but it's not like recent history at all. This was a long time ago.
You're honestly
Previous
like
history
whether
with
it's
that.
recent or not, the fact that he has violent convictions for a battery and an aggravated battery against the same victim, they still create this case being a felony and they're relevant today, regardless of when they happened. Them
I
being in a
understand.
relationship for 16 years is what you're using as an argument for why, people get in fights. They love each other. They've been together a long time. You can't then argue that because he assaulted her and was convicted for it in 2011, 12, and 13, that's too remote to have any value here today. They're valuable. They are reasonably.
And they may well be valuable. I'm just saying it's a long time ago, and they share 4 children. I think that is significant. It says something about the enduring nature of their relationship. We may not like what happened there, but I'm just saying they obviously have stayed together for 15 years. And it's not like they've had a constant history of, this kind of stuff. This happened last year, and that is also a fact. In November of last year, that is when it's alleged that this happened. If my client receives a very high bond or a cash bond, he just cannot pay it. I'm just stating something that is a fact because he's been locked up for some time. So I'm asking the court to take that into consideration. Nothing further.
All right. I'm going to issue the 15,000 surety, and that'll be 8 on the battery, 9, 10, 11, 12, 1,000 on the cruelties, and I thought 2 on the obstruction. Let's check my math. 10, 11, 12, 13. Is that 14,000?
Yes, Your Honor. We're still missing 1,000. If you could do 9,000 on the battery, 4,000 on each of the cruelties, and 2 on the
Let's
obstruction.
do that. nine on the battery and then 1,000 on the others.
Your Honor, if I may say, it sounds like this is more punitive than anything else. He's really not in a position to pay for bond. This is, after all, a misdemeanor. It was determined to be a misdemeanor by the DA's office. After they sat on it for a while, were able to look at the allegations. They came to the decision that this was a misdemeanor. And his bond just does not sound like a misdemeanor bond. It sounds more like a felony bond. And it sounds extremely punitive, given the fact that he's been sitting in jail for all this time and that this incident happened 6 months ago. I'm just asking the court to take that in consideration and to cut the suggested bond by at least half. The 15,000 is very high, Your Honor. And
Well,
I know that
actually,
he's
that
not in.
doesn't sound like the felony bonds. The felony bonds are much higher than that, actually. But I'm very concerned that continues to get cases with the same victim and in front of her children. I don't know that he deserves much leniency at this point. And I guess for whatever reasons, they did not want to prosecute it as a felony, but I just think, and you say he's been in jail all this time. What's the arrest
Yes, Your
date?
Honor.
April the
ASGL?
3rd.
April the 3rd. Well, I'm going to stick to the 15,000 surety, just due to the nature of the circumstances as well as the repeated history. You know, sometimes they say, well, because there is no case, maybe things were cooled off and didn't happen. Sometimes it's just because the victim is just as tired and frustrated of continuing to come to court and maybe feels like that the system is failing her. And she stopped calling the police. I don't know. But I'm going to stick to the 15,000 surety. And no drugs, alcohol, weapons, or guns while on bond. He's to have no further contact with the victim, Erica Johnson, and or her children, and to stay away from her place of residence as well as where she works.
Your Honor, my client tells me that he has custody of the 4 children. Is it possible for him to have third-party transfer of the children?
I see a attempt to establish child support out of DeKalb County. I don't see a final order. I don't see anything in Fulton County where this address is and where she lives. So I would love to see something related to the biological mother of these children having her parental rights taken away, but I don't see anything like that.
And where did he get custody from?
I don't know, Your Honor, but he told me
How
that he
did he
has
get
primary custody of them. So I'm just going by what my client shared
Where
with
were they
me.
married? Were they married in Fulton or
Yeah.
DeKalb?
I am not sure. My client wants to say something. Just say whatever you say. Let it be about the custody situation, okay?
Good morning, Judge. Last year at the time, Erica Johnson is currently on bond for person recruits for children. At that time, my parents had kinship. After the kinship later on last year.
So I guess the question is, what authority has granted you? So is it DFACS? Is it a superior court? Where is it?
Sounds like it might be defects because she is on bond on a cruelty
I would like to hear
charge.
his answer, but I got it.
After sitting down, DFACS granted me custody. All the paperwork was sent to the Goodman out of the public defender's office. DFACS granted me full custody of my 4 kids.
What court?
Out of DFACS.
Defects, he said.
What's the kind of DFACS? They closed my case last year. They took my parents had kinship, not a kinship. I won custody over my 4 children.
I'd love to see something to that effect. I don't see anything in Fulton County system related to that.
It was sent to the public defender's office, Superior Court. Ms. Goodwin has those emails.
Okay. Well,
And we don't see it though?
I don't see anything.
So he's
It's in
there,
custody.
and so they were married. I missed that part.
No,
And he hasn't legitimized them.
Yes, I think he's saying because she was charged with cruelty to children. At that point, these facts stepped in and gave the children, they gave the children to him.
And so at the time of this incident back in November, where were the children residing?
With her in her home.
With her in her home.
He says no.
Okay, well, I look forward to litigating this further, but at this point, I don't see anything that says the victim in this case from November, who is at home with her children right now, doesn't have custody of those children. I don't see anything that says this man ever married her or has been deemed the legal father of these children, period. I do see where he's been convicted for assaulting her in front of them, and he's got open cases for assaulting the children. That's what I see.
Excuse me, Your Honor. If I may speak.
One last thing.
If I may speak. Yes, ma'am. On the 23rd, those cases were thrown out by the prosecutor's office. The ones she's referring to by punching the check, those cases were dismissed on 4/14/2025. The children right now should not be around her. And also, an incident happened on 4/22/25. Ms. Goodman has information where an additional incident happened while she was on bond. For no violent contact, she struck the children and ended up leaving one to my parents' office. That's been documented since the public defender's office.
Well, it sounds like they shouldn't be with neither one of you, to be real frank about it. But I'm concerned if something, like that was dismissed or whatever in April, ASG Allen should be able to see that they were dismissed. She doesn't see that.
I see, well, the case we have in front of us was dismissed by the DA's office. I do see that Erica Johnson has a bond order that says she shall have no further violent contact with the same child that this gentleman is accused of assaulting. Nothing about it saying she can't have contact with her children or that they've been taken from her custody. And that is
that April?
July 2024, which is before our incident here.
For this one, yeah. So she's just supposed to have no further violent contact, which we tried that with you as well. The more we talk, the messier it gets, and these poor children are the most serious of victims, going every which way. I feel bad for them more than anything. So maybe you can just apply for a modification once we figure it out. But I just, nothing about this makes me feel good at all in trying to protect these kids, maybe from both parents at this point. But I'm going to stick to the dad on this because he's not legitimized him. I don't see, they may have given him some temporary custody at some point and then it went awry after that. I don't know. So we have 9 on the battery, 1,000 on the cruelty, 9, 10, 11, 12, 13. I'll bring it down to 14. So 9 on the battery and 1,000 on the others. 14,000 surety. And then the stay away and no further contact with her. I'm not going to order any third-party transfer of the children at this point. I'm not comfortable with that. So he should just no further contact with the kids or her until you all can sort it out, get some orders together, bring them back and ask for modification if we find out otherwise. That's the safest way at this point. All right, thank you.
Thank you, Your Honor. That concludes my business before the court today. May I be excused?
Yes, have a good weekend.
You too, Your Honor. Thanks.
All right, thank you.
Hey, thanks for watching. If you enjoyed that video, do please take a moment to like, subscribe, and leave a comment on the video. We'd really appreciate that. And if you want to keep the fun going, check out the video on the screen right now.